Chris Fowler of the Nashville Bar. I represent Alliance Realty Management Company, LLC. If it's all right, I'm gonna just call them Alliance, so I don't have to keep spitting that out. This is our appeal from the trial court's order from June 13th, 2022, following a one-day trial. She ruled.
Do you want to reserve any time?
Oh, I'm sorry. If I could reserve 2 minutes.
2 minutes, okay.
So sorry.
It's all right.
Everybody ahead of me messed that up.
Everybody gets wound up when they get to the podium, and lots of people forget.
So, trying to get the order following the trial set aside, reversed, overturned, that found that my client was in breach of contract and was liable for damages that were caused by a tenant. And just briefly to give you the facts, my client is a property management company from Clarksville, Tennessee. They're locally owned. July 1st, 2013, they signed a management agreement with Lavern, Webb. That management agreement was pretty standard, that we would advertise the property, lease it to people. We collected a small fee, it was a 10% commission off whatever the rent was, and tenant misbehaved, we would evict them. If there were problems with maintenance, we would get that fixed. And as part of this management agreement, there were two important provisions. One that says that my client was required to obtain approval for maintenance repairs that were over $200 unless it was a recurring operation charge and or emergency repair in excess of that maximum, and in the opinion of the agent, such repairs are necessary to protect the property from damage. Next important provision is that, and this is paragraph 4, the agent also shall not be liable for any error of judgment or for any mistake of fact or law or for anything which it may do or refrain from doing hereinafter, except in cases of willful misconduct and gross negligence. So with that contract in place, August 3rd, 2015, my clients, and it's kind of an awkward contractual situation, I understand, but they've signed a separate lease on behalf of Mr. Webb for the Pearsons to move in. And while the Pearsons were there, HVAC continually went out. My client would go out and fix it. They would ask Mr. Webb to replace these units that were completely gone at that point. Mr. Webb would refuse. And so my client was in this impossible position of, do I spend Mr. Webb's money to fix this, or do I let these people stay in this house that was above 100 degrees? And I realize you don't have the transcript of the actual.
Counsel, I want to ask you about that. We don't have a transcript here.
Sure.
And if I recall correctly, we also don't have a Rule 24 statement of the evidence in this case, or is there a Rule 24 statement that was filed here?
There's a notice of no transcript. I'm not sure that there was a statement of evidence.
There's no the notice says there's also going to be no statement of the evidence.
So given the fact that there's no Rule 24 statement and there's no transcript, isn't this court required to presume that the facts would support whatever finding the trial judge reached in this case? And so you say, well, they weren't liable unless there's gross negligence. Don't we have to assume that the facts would support gross negligence, for example?
So just kind of jumping ahead, so you're getting to my argument, but the reason I would disagree with that is because the order that was presented and entered by the court as a final order, it provides no facts as to how they get to the decision that my client breached the contract, how my client breached the contract, how my client was willfully misconducting themselves, how they were grossly negligent. There's nothing in her order that would allow the court to hear this appeal or to allow me to present an adequate appeal.
Well, couldn't you pursue a Rule 24 statement and clarified essentially what the facts are in this case, and showing that, for example, the conduct didn't rise to the level of gross negligence? And my understanding, and correct me if I'm wrong, but if there's no transcript and there's no Rule 24 statement, my understanding is we have to presume that the facts support the finding. And so maybe there weren't sufficient facts presented in this case to show gross negligence, for example, but we have no way of knowing that without a transcript and without a Rule 24 statement. So this court's going to be able to exercise review on this question. I don't know how I'm struggling to see how we do so. And I take your point in terms of the the order, does the order have sufficient clarity with regard to factual finding? But I'm not sure how we even get to that point, given that we don't have a transcript and we don't have a Rule 24 statement.
Understood, Your Honor. If I could just make my other arguments. The court did not even address this negligence, grossly negligent standard, or whether we were willfully misconduct.
Counsel, let me ask you about this willful misconduct or gross negligence standard. That is found in a clause in the contract that talks about save harmless. Normally, contracting parties don't save each other harmless. You're saving harmless from third-party claims. In fact, the language that comes before that sentence that you refer to is talking about an insurance policy, obtaining insurance to list the management company as co-insured. So, as I read that provision, that really limits liability for third-party claims, not claims by the owner. Why is that interpretation incorrect?
Just as a plain reading of that sentence, it says that the agent is going to not be liable for error of judgment. And I understand you're saying that it's in a kind of a different context.
I guess let me give you a hypothetical and see where it might go. So one provision of the contract says the management company is going to seek prior approval for expenses over $200. And suppose your client just said, you know what, I know the contract says that. I'm not going to do it. Just not going to do it. So you have to prove to be able to get any liability for that gross negligence or willful misconduct?
Under your scenario, I think that is willful misconduct, but your point's taken. I mean, if I could address what is actually in the order, it does address that the Pearsons, and I'm going to use round numbers, but effectively damaged this property by $7,000. And the order then goes on to assess that $7,000 against my client, Alliance. We would ask that is improper and should also be assessed against the Pearsons, who I don't believe are here today. Arguments that the standard that was applied is inappropriate. The court failed to specially find the facts under Rule 5201, which I understand you've already addressed, and that finally...
and you filed a motion to alter amend in this case.
We did.
And asked for a determination of where the conduct here was grossly negligent or willful misconduct. But I noticed that the motion to alter amend doesn't say anything about, and also your finding of fact inclusions law are deficient here.
Respectfully, Your Honor, the motion was to say, Your Honor, please put in an order where we were grossly negligent. In the order that was submitted back just says that the motion's denied and the order entered on June 13th is the final order of this honorable court. So we did ask for clarification of, we don't think we did anything wrong, but if we did, tell us what that is.
In fairness, it's really more about tell us where we're grossly negligent or we're engaged in willful
Correct,
misconduct.
Your Honor. So, unless there's other questions.
No,
Thanks.
thank you.
May it please the court. My name is Tiffany Loeffler, and I'm a member of the Montgomery County Bar, and I represent Lavern Webb in this matter, in this appeal. Essentially, I was not trial counsel in this and was requested to brief on this, and I would say, based on the facts before the court, that that the trial court should be affirmed in this matter. Rule 24 of the appellate procedure requires a statement of the evidence or a transcript of the evidence, and neither was provided. And absent that, Tennessee law is clear that absent those things, there is a conclusive presumption that there was sufficient evidence before the trial court to support its judgment. I know appellant has stated, there was this testimony or that testimony, but we don't know that. There was a request filed after this appeal was filed for a supplemental record asking for the pretrial briefs in this matter, which we did file an opposition to, basically saying that that was improper as well, but then is trying to use that as the facts of this case. And again, that's not proper here. That side alone, beyond that, there are no really strong assertions to support their claims based on the record and based on what's before this court today.
Counsel, does the failure to file a transcript or a Rule 24 statement relieve the trial judge, though, of her obligation to make findings of fact and conclusions of law? And doesn't the trial judge still have an obligation to make those sufficient findings of fact and conclusions of law for this court to know what the basis of her ruling was and to not have to guess at it?
Absolutely. I mean, it does not absolve the trial court's obligation and requirement to do that. And I believe the trial court order could have been more efficiently and effectively drafted, but I don't think it's fatal in this case to remand entirely. The trial court doesn't have to necessarily treat each individual aspect separately as long as it has findings as a whole are hitting all the relevant facts necessary. So yes, I do agree that the trial court needs to make sure that their orders are appropriate and sufficient. In this case, it is not as well done as it could have been, but I don't think that that's necessarily fatal in this instance.
The damages in this case, if I'm recalling the order correctly, there's a reference to an exhibit that has damages, pet cause damages to the property that the Pearsons in terms of what's occurred here. Given that, in looking at the order, do we have a clear explanation of how you get from tenants' pets cause significant damage to home to Alliance liable for pet damage caused by tenants? And where in the order would you point us to get from that damage, which seems to be referenced in the order, to liability for Alliance for the damage caused by the tenant?
I don't have the order before me, but I believe, that taking all of it as a whole, and as the contracts, those were the damages assessed based on what was presented to the court. And Alliance was relied upon to manage this property efficiently and effectively. And again, we don't have the transcript to show, but based on the other pleadings, Alliance was not doing what they were supposed to under the contract, and that in and of itself was a breach, and they became responsible for that because they were responsible for that property for the duration of the contract between Mr. Webb and Alliance Realty. The fact that Alliance wasn't doing what they were supposed to under its contract with Lavern Webb, I think, is what was fatal to it in this instance.
So are we supposed to, I guess we're supposed to assume that?
I think that there's a lot of assumptions made here, yeah.
No transcript, no statement of the evidence, and insufficient findings. So we don't really know what happened.
Correct.
In any of this. And the question is, where do we go from here? And, often if one has insufficient findings, one sends it back to the trial court. But there's no transcript or statement of the evidence, and traditionally that means that justifies what the trial judge did, except the trial judge didn't say what she did. So it's a little bit of a conundrum. What comes first, the presumption arising from no transcript, or the fact that there's no findings?
I mean, I think when you file an appeal, you need to do the appropriate appellate procedure. But I mean, I agree that there is a conundrum, and I do concede that the order is not as complete as it should have been. I know that in that judicial district, it's the judge makes a ruling from the bench, and then trial attorneys go and draft the order, and that's probably where a lot of that fatality comes in. And but I think, again, you know, I don't know if it's to the point where it's fatal, where we have to go ahead and reverse it all. I think that, again, there was enough to show why the court made its decision. You know, could it have been a lot more detailed and specific? Absolutely, but I don't necessarily think that there was to the point of fatality in which it needed to be remanded.
The damage award is related to Pearson's is smaller than Alliance, if I'm remembering correctly, a few $100s. Is there any explanation in the order of why the Pearsons are not on the hook for the full extent of the damage caused by their pets in this home rental? And even if they're jointly liable, or is there any explanation in the order as to that?
I don't believe that there's any in that order, no. And I know that their damages award to Mr. Webb was significantly smaller. I believe that the trial court only ordered them to pay the pet deposits, which were not paid to Alliance, and their contracting with the Pearsons. But I don't believe that the order says why Alliance received more of that damage assessment than the Pearsons. But I think that we're, again, you know, I think we've addressed, you know, here today as well as in the brief, that we are at kind of a conundrum where we don't have a transcript, we don't have significant evidence before this court, but based on what we do have in front of this court, I would say that we need to just affirm the trial court. And if there are no further questions, I'll just rest on the arguments in my brief. Thank you.
No further questions.
Thank you.
Mr. Fowler?
Yes, briefly, and I appreciate the court bringing up the Rule 24 requirement. And I'd say this is the first time that this has been raised by the appellees in this case. Second, I'd say that the order that was presented, that Judge Fry signed on June 3rd, 2020, I mean, to say that it was written by anybody, it was you can see by the order that it was drafted by Mr. Webb's counsel, who was Jacob Mathis at the time. There's nothing relevant factually in the order to find against my clients. We'd ask the court to either remand the case for findings of fact and conclusions of law, or to send this back for a new trial. So, thank you.
Thank you both.